Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is when is personalized pricing unlawful? Current and prospective private litigations in China. If you're like me, you do some or most of your shopping online, and you feel like you're a pretty savvy customer, good at finding deals or best prices for your favorite items, until you realize you're not. Not only you have been charged different prices based on your purchasing habits or patterns, you may have also been discriminated based on whatever the merchants may have known about you based on big data. Would you as a customer feel harmed in some way that you want to challenge this practice commonly known as personalized pricing? Some customers in China decided to do exactly that and brought several civil lawsuits against e-commerce platforms, including online hotel booking, ride-hailing, entertainment ticketing, and many other industries. When does this personalized pricing practice based on big data become illegal in China? Today, we're going to learn a bit more about that. Joining me today is my co-host, Lijun Zhang. Hi, Lijun.
Hi, Anora.
So personalized price litigation in China, we're going to talk about that, and we have a good guest. Is that right? Who is our guest?
Yes, we do. Dr. Annie Xue is an attorney at Zhang Law Firm. It's GEN. She's based in Beijing, heading the firm's compliance practice. Annie specializes in regulatory affairs in data privacy, protection, antitrust, and anti-unfair competition laws. Annie represents leading internet firms and patent owners in private antitrust litigations, including antitrust litigation arising from a platform's practice of personalized pricing, and is adept in handling overlapping issues among antitrust, data security, and other compliance issues. Annie studied competition law at the Law School of University of Illinois at Urbana-Champaign, where she obtained a JSD degree. Annie was also a postdoctoral fellow at the Institute of Law of the Chinese Academy of Social Sciences, where she took part in research efforts led by Chinese legal enforcement authorities and academia. Over the years, Annie has actively contributed to the making of competition and data regulatory policies in China, authored many articles related to data protection and antitrust, and served as a member of expert panel for a couple of provincial antitrust agencies. So we have a perfect guest for our today's topic. Let's welcome her.
Thank you, Arnold and Lijun. Hello, everyone. I'm Annie Xue with GEN Law Firm. I'm a very committed audience of your program, and I'm so happy to, for having me today. Thank you very much. Hopefully, I can share my insights and understanding about personalized pricing in China.
Hi, Annie. Great talk to you. Actually, I don't know about you, but it sounds to me personalized pricing is like old wine in a new bottle. But really, the prevalence of e-commerce has made this a hot topic in China in recent years. Actually, we're very used to price discrimination, right? In traditional commerce, return customers can always enjoy some loyalty discounts. And many of us, at least I really loved it. And in e-commerce, some loyalty discounts based on algorithms are also popular. And they are uncontroversial by and large. But the sentiment seems to shift once algorithms are employed to take advantage of loyal customers, charging them higher prices and offering discounts instead to new customers. In fact, when talking about personalized pricing in China, I heard a term more frequently used is 大数据杀熟, which can be literally translated to ripping off old acquaintances with big data, right? This term seems to give us some clue about why this has been a much criticized practice in the public arena in e-commerce in China. So first off, what is personalized pricing and how does it work in general?
Actually, there's no official definition in China. I don't think there's one in some other major jurisdictions. But let's borrow the OECD's definition. Personalized pricing refers to the practice of price discriminating consumers based on their personal characteristics and conducts. For example, their purchase histories or habits, resulting in a price being set as a function of consumers' willingness to pay. So essentially, goods and service providers, they collect a variety of personal information through various channels. It could be their own platform or some other third parties, so that they can get to know a consumer's willingness and ability to pay, and then set the price at a level that may ensure the largest gain of surplus value from the consumer. That's the basic concept and how it works.
So why has it been a trendy topic recently? Is it just because now those digital platforms have the capability of doing that, or is it deeper than that?
Yeah, I think it's kind of deeper than that. First of all, the Chinese firms are catching up very fast in terms of digitalization, thanks to the government's strong encouragement and empowerment embedded in China's industrial policies, and probably a little bit because of the relatively relaxed antitrust enforcement in the platform sector in the early days of antitrust. Data, including personally identifiable information, in short, we call it PII, has been officially recognized as a production factor. So it's a very important ingredient for industry. They're hungry for that. And in the meanwhile, China also has a GDPR-like very rigid data privacy laws. As such, in almost the largest data-driven economy, with one of the strictest personal information protection laws, personalized pricing, an issue standing at the intersection of antitrust and data privacy, naturally becomes a focal point in both sectors. But personalized pricing actually is a sort of price discrimination. For price discrimination, I do not necessarily mean it in a negative way, because in economic terms, actually, it's a neutral way to set up a price. It really depends on whether this kind of practice will, infringe upon certain legal interest or rights of the individual consumers. So it's not a new thing, just in a new form.
Got it. So price discrimination, as you said, most of us learned it in Economics 101, right? So it's a neutral term. But when we're talking about price discrimination in the digital era, is there any unique characteristics of such price discrimination that we should pay particular attention to?
Yeah, essentially, actually, the new sort of price discrimination is empowered and actually encouraged by big data and algorithm. These are kind of two new phenomena in the new digital economy. So what we have to pay attention is how the platforms or the service providers, or sometimes some traditional goods providers, they collect personal information and use it, empowered by algorithm to so-called reap the benefits of the legal interest, legal rights of the individual consumers. Yeah.
So when we talk about the legal rights, is that privacy rights or other legal rights involved?
Yeah, definitely. It's natural to think about privacy rights. And, data privacy law right now is a very kind of popular legislation development in many countries. But actually in the sector of personalized pricing, it's not just about privacy rights. It's also about consumers' fair trading, the right to information, and sometimes to fair trading. And in some other cases, it may also about the competition order, which is defined under the antitrust laws.
When you talk about fair trading, I understand you mean fairness. What is inherently unfair about this personalized pricing exactly?
Yeah, for example, I'm a consumer, and of course, I'm aware that sometimes when I use some app or platform services, I have to submit my personal information because it's essential to achieve the basic functionality provided by the platforms. But sometimes the service providers or the platform operators, they do not provide full information. They do not fully disclose how they will use my personal information, especially in the case that they may use my personal information to do profiling and set up a relatively higher price for me. Absolutely, that's not anything I expect when I submit my personal information. So, which basically means that sometimes personalized pricing may lead to may means sort of like false information disclosure or some misleading representation by the service providers, and the consumers may not make their true decisions based on accurate and complete and full information.
Got it. So let's say if a company collect all those customer data in a lawful manner and they obtain the customer's consent and they fully disclose their use of the data for algorithms in generating those personalized pricing. So if the company does all that, is there any other unfairness involved in the personalized pricing?
So as long as platform operators or service providers, they collect and use the personal information in a compliant way, I don't think it will bring quite some compliance concerns in terms of data privacy protection or consumer rights protection. But still, setting apart, the personal information protection or consumer protection, still the platforms, they need to pay attention how they would process and use personal information to avoid unfair competition or antitrust concerns.
Mm-hmm. So you mentioned antitrust. So let's get to the legal framework under which personalized pricing has been litigated in China. So I understand there are multiple legal avenues to approach this issue. So could you just give us some introduction about the legal framework we should look at when analyzing this issue?
Yeah, actually, not only in China, but also in many other major jurisdictions, the authorities or the plaintiffs, they approach personalized pricing through multiple avenues. It could be antitrust law, where the business operators have a dominant market position and they rip off the consumers. But it happens only when where the jurisdiction applies also punish explorative practices, not just the exclusive practices in antitrust law. So there are some doctrine differences across different jurisdictions. And sometimes it's also contract law could also be a institutional instrument to address this issue, because oftentimes the users or the consumers, they sign a contract. Actually, privacy policy is also part of their user agreements. So sometimes, the platform operators, they misuse personal information. It's a breach of the user agreement with individual consumers. And, also, for example, in some of China's personalized pricing related litigations, they choose to use something like torts law or consumer protection law. In China, the torts law has already been integrated into civil code, where, it's very hard for the consumers to prove that there is a anti-competitive behaviors under the antitrust law, because the burden of proof is pretty high. So normally they may go with consumer protection law or torts law. I have mentioned the consumer protection, and also price law could also be another avenue, because in China's price law, there is a very clear prohibition about discriminating different consumers if they are samely or similarly positioned. So all these are the major legal avenues that the plaintiffs and the authorities could approach personalized pricing.
Does anti-unfair competition law of China also provide a legal avenue to address this issue?
Anti-unfair competition law play a role in a lesser sense because normally the anti-unfair competition law address the unfair competition practices between business operators. But the personalized pricing, as you can see, it's a individual involved. So, and normally individuals, they are not business operators. So I would say it's rare to be seen, where anti-unfair competition law would be used as a legal basis.
So that's the existing legal framework that we're looking at. So are there any policy changes or legal changes on the horizon that is relevant to this issue?
Yeah, what I mentioned are traditionally the major legal frameworks, but nowadays with the coming up of the personal information protection law, data protection law, and cybersecurity law, so the individuals, they have some other choices if they want to protect their rights, because essentially all the issues starting from the collection and processing of personal information. If the business operators, as you said just now, they collect and process personal information in a compliant way, so normally they're safe. Yeah.
Understood. So I think we mentioned that there are a lot of litigations that's happening in China. So let's break them down into public enforcement action and private litigation. So are there any public enforcement actions in recent years? Can you just give us some examples, and what are they generally about?
Yeah, actually, when it comes to personalized pricing, there are rarely any public enforcement. Especially, there's no one under the antitrust framework. That's a big issue or big topic, because oftentimes people think that when speaking about personalized pricing, it's all the misconduct of the big platforms. But actually, although in recent years there were many public antitrust enforcement investigations, penalties against the big platforms or big tech companies, but actually there's no one about personalized pricing.
So let me just clarify one point. I thought I've read somewhere there are fines made to online travel agencies or some other e-commerce platforms for their irregular pricing practices, which could include pricing based on big data of customers, and those fines. When you're talking about a public enforcer, you meant the government
antitrust
antitrust lawsuit in court, or are you saying the distinction is whether antitrust or not, or whether it's in court or not?
Whether antitrust or not, because in China the antitrust enforcement does not have to go through the court systems. They can just hand down a administrative punishment. But so far, there's no public antitrust enforcement against or regarding personalized pricing.
But the fines that have been issued by the agencies are not antitrust laws. Is that right? But there are fines.
Right. Yeah, it could be like price law or some consumer protection laws, but somehow it's not antitrust law.
So is there any example that the government authority used other legal avenues like price laws to enforce against personalized pricing in recent years?
If I recall well, in Zhejiang, in a small county in Zhejiang province, there's one case, and it's a rarely seen case because I have never seen a second one or similar one. about so-called personalized pricing. It's also about the platforms, how they charge different prices against different consumers.
So it sounds like the bulk of the litigation activities may reside in private litigation when it comes to personalized pricing. So can you give us a couple of examples about the private litigations that are happening in China on this topic, and what are the general claims?
Yeah, definitely. Actually, in recent years, there are a handful of private litigation regarding personalized pricing. They're not necessarily under the, as Anora said, antitrust law, because it's kind of hard for the private plaintiffs to prove the definition of relevant market or the market dominance of the defendant. So at first, what you can see is the consumer protection cases brought by consumers against the OTA, online travel agencies, because they collect consumers' information and use their purchase habits, their characteristics to set up different prices against different consumers. And sometimes they, for example, there is a kind of a high-profile case about Ctrip. I'm not sure whether you guys can read some news about this case. And in this case, the legal basis is actually the consumer protection law and also the cybersecurity law, because at that time, the personal information protection law has not been released yet. So basically, what the court said is that, Ctrip, you are a major OTA having a superior market position, but you collect the personal information and use it and kind of misuse it by, exceeding the original scope you disclosed to the individual consumers. So basically, you are overusing the consumer data, and you share this data with your associated companies, which will definitely increase the risk of the infringement upon the personal information rights of the consumers. And after the Ctrip received the complaint from the consumers, it did not respond in an appropriate way and according to the judgment, even in a fraud way. So basically, the final judgment said that Ctrip will have to return what the consumer has paid and make and also subject to treble damage. But it's not like the treble damage under the Sherman law framework, because under the Chinese consumer protection law, if you are doing anything fraud, you are subject to punitive damages 1 to 10 times of your legal gains. So that's a case about the Ctrip. It's pretty much high profile, and there's one case which is filed under the antitrust framework. It's against Alibaba, against the Alipay and Ads Group. But unfortunately, the plaintiff was not able to, according to the courts, define the right relevant market and prove the market dominance of Alipay and all the other defendants. So the plaintiff did not win the case.
So you have been using singular form when you refer to plaintiff. I was wondering, so those are individual plaintiffs, right? Are there any class action mechanism that may be available for plaintiffs in seeking remedies in this regard?
Yeah, I think it's a very good question, because what's powerful, we are aware that what's powerful in the US about antitrust law is that you have very powerful class action, private antitrust enforcement. That's the real teeth of the antitrust. But in China, actually, we do not have the class action in the U.S. sense. We only have the representative litigation 代表人诉讼. So it's not easy to do this kind of case. And also, as you can see, personalized pricing are all about individuals' rights. So it's very hard for the individual consumers in China to organize, get together with all the other consumers and, to file a lawsuit. So yes, so far there's no class action. But in China, we also have public interest lawsuit, which can be filed by the prosecutors. But so far, personalized pricing has not become has not drawn the attention of the prosecutors. So yes, so far, almost to my knowledge, all the plaintiffs are individuals. So just one.
So it's those individuals who are using their personal wherewithal to fight against those large companies in those lawsuits. Is that what's happening?
Yes. But from what we can see in the public information from the news is that, sometimes it's kind of, basically the plaintiffs, they are facing two major barriers to file a case about personalized pricing, especially under the antitrust framework. Because one is that, you have to have the knowledge, for example, the legal knowledge about the different legal framework. You have to pick up the one that's the easiest for you to make a case. And you have to have some technical knowledge, or at least you have the money to engage an expert to help you to figure out for example, the algorithms or the basic technology, background technology information to support your arguments. That's one barrier. And the second one is that you have to have, you have to pay quite some time and financial cost, which for individuals are very hard. So if you look at the cases, for example, the Alipay case, it's the plaintiff actually is a so-called financial scholar or financial antitrust scholar. It seems that she has she's a sophisticated consumer, has kind of more not having more knowledge than average consumers, and he is very active in the social media. But the C-Trip case, it seems that it's just a regular consumers. Although we may have some doubt that, not some doubt, have some question marks about whether they have some support, from other parties, for example, competitors, but it's only a question mark, and no one has proven this side.
This is interesting. So from a legal perspective, what do you regard as the key disputes around those enforcement actions and litigation of personal pricing? Like, what's your observation and what's your thought? What are your thoughts?
Okay. I think for the plaintiffs, and actually it's also true for the antitrust authorities or any authorities to prove the harm to competition if this kind of case is brought under the antitrust framework, because normally in China or some other major antitrust jurisdictions, you do not, as a private plaintiff, you do not only prove the damage to you, but you also have to prove the harm to the competition generally. So, but it's very hard because personalized pricing points to individuals, and there's no next level of value chain where there will be unfair competition occurring. Or any business operators will be put in less advanced competition position. So it's kind of hard for them to prove this point. And for the individual consumers standing to sue, it's also an issue because just because of the same reason as I mentioned before. Normally, they can very easily prove that, hey, I get a kind of more expensive price or get less discount compared to some other individuals. But still, the next question by the judge, where who work with the chamber of accepting the case. So where is the harm to competition? So why would you bring this case under the antitrust law? So that would be a major barrier for the standing to sue difficulty. And the third one would be how to assess the damage. It's kind of hard because, in China, we do not have treble damage as in the US. If I just, feel that I get discriminated with regard to price, but I only have, 3 RMB, more than the price you have, or I have 10 yuan less discount than you. So it's kind of hard to really assess the damage, because the damage to individual consumers or plaintiff is so small. It's so small. I cannot ask for apply for the damage to the whole consumer community, because that's not how the case works here in China. It's not a class action.
And I may have missed this. So what are the outcomes of the litigations that have already been filed by customers against e-commerce platforms? And you mentioned the several barriers, including standing, and then their difficulty in proving damage to competition, not just themselves.
Yeah.
Have those barriers been preventing the customers from winning in their private litigations so far?
Yes, for example. But what I said about the barriers is about the private antitrust for litigations. It's not the private litigations about personalized pricing under the consumer protection law. For example, in the C-TRIP case, the legal basis is consumer protection law and cybersecurity law. It's really relatively easy for the plaintiff to prove that, hey, you collect my personal information, although you disclose that, you will use it to do the profiling, but you have never told me that you will use it to set up a higher price without my informing me of these kind of processing activities. That's kind of a fraud. So
right.
So in this kind of case, the barriers are not such high, but in antitrust cases, the barrier is high. So basically, the standing to sue and how to prove the harm to competition and how to assess the damage, especially why the damage, a claim could incentivize individual consumers. It's hard, right? If it's only 3 yuan or 1 digit damage, it's kind of hard, and it makes people to have doubt or suspect what's the motivation of the plaintiff to make this expensive antitrust litigation.
Right.
So and in the Alibaba case, go ahead.
So it sounds like a real risk and perhaps a more suitable place to resolve the challenges that may be brought by customers is under consumer protection laws or data privacy laws rather than competition laws in China. Is that right?
Yeah, for the plaintiff, I think yes. And for example, in the Alipay case, actually the plaintiff was not able to, win in the first step because he did not, according to the court, define the market properly and prove that the Alibaba or the Apple Pay have a dominant market position. So not to mention that they abuse this dominant market position. So all these are very kind of significant barriers for the plaintiffs.
Is it fair to say that what we have observed is a lot of lawsuits brought under consumer protection laws, perhaps addressing consumer protection issues, but using languages of competition law, sometimes including dominance, and then what the market share of a platform might have, would have been some languages or allegation that have been used in customers. Is that a fair observation?
True. Yeah, that's true. Because oftentimes when people speak about personalized pricing, big data, and algorithm, they naturally associate it with big platforms or big tech companies. So basically monopolists or oligopolists. But actually, this kind of behavior does not necessarily lead to anti-competitive impact. Eventually, probably today we do not have sufficient time, but somehow actually price discrimination, as I said earlier on, is neutral. And many market structures actually just accept the monopoly, this kind of market structure. At least there were two more market players. Personalized pricing or price discrimination actually it's good. It can help to intensify competition or expand output. So actually it's a neutral. Just when it comes to personal information, it's very easy for people to feel that you get decepted and your personal information is misused, and it will make average consumers to lose trust or faith in the internet economy. I think that's the externalities, especially negative externalities of personalized pricing. Yeah, but whether or not antitrust law is the right legal framework or legal or tool to address this kind of issue, it remains a question mark. And in many other jurisdictions, it's not. They do not use antitrust law. Yeah.
Got it. So since those litigations are on the rising, so do you have any advice for people doing business in China, and especially foreign big companies that may face certain risks in that regard?
Yeah. So personalized pricing actually is not per se illegal, actually in any legal framework. So it's a neutral pricing practice, but business operators have to consider compliance, especially personal information protection compliance and consumer protection compliance in the first place. Of course, when the algorithm and the regulation over it, for example, China recently rolled out the first AIGC laws. All these kind of laws also govern or regulate algorithm, which is related to personalized pricing. So basically, I think the business operators should pay attention to data collection, processing, consumer protection, and the compliance about the algorithm. So all those are very important ingredients for a compliant, personalized pricing practice.
Well, thanks, Annie. This has been very interesting and fascinating. So let's now turn to a more personal segment. And we would usually, before going to that, ask you to tell us something about you that people don't know if they have just known you professionally. What would that be?
Thank you. As a committed audience, I'm quite familiar with this part. So after second thought, I would say for me, I would say bodybuilding. Why I say that? Because I consider it a miracle happening to me, especially given my, I would call it just the so-so starting point. Because when I was younger, I never hit the passing score for middle school and university girls 800 meters testing. I never pass it. But after years of private training, I would say miracle happens. Right now I can run kilometers every week, and I ride bike. Oftentimes, I can ride like 30 kilometers. So, and right now, I look much fitter than before. So I would say it's a miracle happens to me, and I committed to this kind of workout exercise as I'm committed to many like my professional or career work. So I would say it pays off.
Was this a result of the pandemic where you have to spend energy somewhere, or is it actually before?
Yeah, actually, after the pandemic, I really get bigger. So I have decided to do a serious workout. And fortunately, I get the right trainer. So miracle happens to me.
Oh, good for you. And in the same effort to know you a little better on a personal level, do you have any advice for young professionals or students who might be interested in doing what you do?
Yeah. Actually, I do. And there were, a couple of very talented young professionals in my team and in my firms. I would say, especially for the young professionals with East Asian culture background, because, normally they are very, diligent and obedient. But I think it's also very, very important for them to be independent, to have critical and creative thinking. It's very, very important.
I thought the whole episode about this is not to do online profiling. We just did profiling, which is fine. Go ahead.
Yeah, because having independent, critical and creative thinking is very important. I would say itself is also critical to adapting to the fast changing area. We have AIGC, we have probably even more smart AI agents. So we have to be smarter to survive in the, digital economy. Yeah, that's a very sincere advice to young professionals.
Yeah. Now let's turn to our final segment called The Curious Hat.
And now it's time for The Curious Hat.
So, Annie, in this little game, what we play called Curious Hat, we usually ask you to pick a number from 1 to 15 out of an imaginary hat, and where there would be some random trivial questions. Would you give us a number?
9.
9. Totally rigging this. So, the question for number 9 is that, what's your favorite junk food? I guess that doesn't really go well with your body view story. But do you have a favorite junk food?
Yeah, actually, I do, but I haven't created it for a while. Actually, I like the fried food. Any kind of fried food, I really love it, but I have quit.
I see. So it still holds a special place in your heart. You're just resisting that for your bodybuilding interest. Is that right?
Yeah, that's true.
With that, thank you for listening, and stay tuned until the next time, Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.